Good afternoon, everyone. My name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. I'm very happy and excited to invite you here today for an incredible learning experience brought to you by several organizations that are really meaningful in this sphere. First and foremost, I'd like to thank the Florida State University College of Law Public Interest Law Center, and specifically the Claude Pepper Elder Law Clinic, which is a part of the Public Interest Law Center at Florida State University, for putting this on and being a part of this training initiative. Second, I'd like to thank Disability Rights Florida for all of the training that they do in these important spheres of law, but also just the incredible work that they do on a regular basis. And finally, I'd like to thank the Public Interest Law section of the Florida Bar for jumping on as a co-host and always supporting these learning efforts. Before I continue on, I should provide some housekeeping announcements on accessibility. First and foremost, for all of you who are here today, we have a couple of options to increase accessibility to our conversation. First and foremost, we have an American Sign Language interpreter interpreting live today. Those of you who have joined us in the virtual world should see the ASL interpreter spotlighted onto your screen along with the PowerPoint. If that is not what you are seeing, please reach out to me and message me. That way I can try to troubleshoot and get that appearance to be accurate. Secondly, we do have closed captions. The closed captioning is enabled, and those closed captions are being provided by a CART writer. And there's a CART writing link also in the chat for you here today. But if you want to enable those closed captions, what you'll need to do is just go down on your screen to the three buttons that say More and click Show Captions. Again, if you're having any issues with that, please message me directly and I will work to onboard you and make sure that accessibility is functioning the way it's supposed to. So, other housekeeping announcements very quickly. All of you should be able to use the chat and the Q&A function. We encourage you to please ask some questions and please drop them into the Q&A function. That would be a little bit easier for us to filter through. Any questions that you have, don't be shy. I know it's very tough when we live in this virtual world. That makes it a little difficult in order to be in community. But we are all here together learning about this important topic. So please feel free to let us know your thoughts, any questions you have. We're extremely happy and excited to answer them. So without further ado, I want to let you all know that this is being recorded, that you will receive a copy of that recording, and that this is accredited for CLE credit. You will receive that CLE code in the chat at the end of our webinar here today. You will also receive it with a copy of the recording, which will come to you in the form of Zoom within 24 hours after this event. I know it's a lot of information. Thank you for bearing with me, and I'm going to turn it over to our speakers to really get into the meat of things. Today with us, we have Abby Kaplan, who is a current 3L at Florida State University's College of Law. And we also have Morgan Patipa, who is an advocate investigator with Disability Rights Florida, and she is a graduate of Stetson Law as well. You may also notice that there's some other folks in the boxes. Those are some of our folks from Disability Rights Florida who are going to be here to aid in the conversation and to help answer and filter through any questions that you might have. So now that I'm done with the housekeeping stuff, let's get to what you're really here to learn about, and that is supported decision making. Abby, Morgan, thank you so much for educating us about this important topic. The floor is yours.
Thank you, and thanks everyone for joining us for this presentation on supported decision-making. This is a collaboration between Florida State University College of Law, Claude Pepper Elder Law Clinic, where I am a current 3L and student advocate, and Disability Rights Florida. I have been learning about supported decision-making over the last few months as part of the clinic experience. And so I'm still learning, but I'm excited to share everything that I've learned with you all today. So next slide, please. Disability Rights Florida is a protection and advocacy organization. It gets federal funding to protect the rights of Floridians with disabilities and has done so since 1977. They do broader policy work and also individual representation, litigation, and things like that. They do some really great work. Next slide. And the Claude Pepper Elder Law Clinic. Students learn and advocate in elder law and policy issues. We do direct client representation, so we draft and execute advance directives for older adults who are low income, and then also do some community outreach. So what are we going to be talking about? We will be identifying the issue, talking about what is supported decision making and its history, the legal basis for supported decision making in Florida, talking about other legal mechanisms, asking if guardianship is appropriate, addressing some pitfalls of supported decision making, its use as a defense against guardianship, and then we'll conclude with success stories and some questions. So, identifying the issue. People experience a range of decision-making capacity throughout their lives. This isn't static. It can change over time and vary across different areas of life. So people who are comfortable with making decisions about what they eat or what they want to wear might not have the same capacity to make decisions about their finances or something like that. Disability and diminished decision-making capacity can stem from developmental disabilities, brain injury due to accident or illness, mental health conditions, dementia, Alzheimer's, or other conditions relating to aging. So the question becomes, how can we advance and safeguard the well-being of those with disabilities? And I just want to point out that I'm going to be using people with disabilities as a sort of shorthand for people with diminished decision-making capacity. But if you have a singular idea of what a person with a disability looks like, I invite you to challenge that and recognizing that we're talking about all of these different experiences when it comes to disability. So what is supported decision making? Supported decision making is a process of supporting adults with disabilities to make their own choices about their lives. So it's not a one and done thing. There's an emphasis on the process and placing the individual with a disability at the center of that process. It can be informal or formalized in an agreement. And it's a tool that we all use in our lives. Anytime that we reach out to a friend or family member to make an important decision or even not an important decision, we are using supported decision making. The next slide, please. So before we get into the nuts and bolts of supported decision making, I wanted to talk very briefly about dignity of risk because it really underlies supported decision making. So making mistakes, everyone makes mistakes, and for most people, we learn from them and we move on. But for people with disabilities, a mistake can set them on the path to guardianship and be used as evidence of their incapacity. But making a mistake or making a bad decision isn't the same thing as the inability to make decisions. People have the right to make decisions for themselves, even if that could pose some risk. And that's what dignity of risk stands for. So supported decision making strives to provide this balance between protecting individuals' rights while receiving appropriate support to mitigate potential risks. So some key features, supported decision making helps the person to understand the issues, options, responsibilities, and consequences of a decision, ask questions, receive explanations that they can understand, and communicate their decision to others. So it's providing support at all levels of the decision-making process, all the steps. And importantly, it confers no authority for others to take action on the person's behalf. So in order to for the person to retain their autonomy, they are the sole decision maker under these agreements. Jump into a little bit of the history. It originated in Sweden in 1988, and I'll just highlight that in 2013, Virginia was the first state to order the use of supported decision-making in place of a guardianship, and then 2 years later, Texas was the first state to codify it into law. There's still a lot to do, as you'll notice. Florida is not one who has codified, so we'll talk about that a little bit later as well. So why supported decision making? Some benefits, as we talked about, the preservation of rights of people with disabilities. It prevents abuse, saves money, guardianship proceedings, and the continuing obligations can get expensive. And it increases capacity through practice. So decision making isn't just one step, it's actually multiple steps. You have to identify that there's even a decision to be made. You have to gather relevant information, identify alternatives, or identify your choices, weigh your choices, and then choose one of those choices and then take action. So for people who don't struggle with decision making, this may come easy, but it's just a skill that you can learn, just like anything else. And so going through those steps with the help of a supported decision-making agreement can actually increase someone's capacity and make them a better decision maker. More benefits, better employment and community integration, increased confidence, independence, happiness, more active and accountable for mental and physical health, and improves the ability of people with disabilities to identify abusive situations. And this makes sense because supported decision making, a person retains autonomy and they are more, they are able to be more active in their own life, and better outcomes result. So this is a map of states that have codified supported decision-making laws. The dark blue are states that have, and the gray have not. The states that have don't necessarily fall along traditional party lines. And as you can see, again, Florida has not yet codified, but we will talk about that again. So supported decision making is backed up by a statute in Florida. The statutes provide many references to requiring the least restrictive alternative to guardianship be used. And this is in Chapter 744, which is guardianship, and 393, which is guardian advocacy. And we'll get into the difference between those a little bit later. But even though there is no codification of supported decision making, the law already supports its use by referring to these less restrictive alternatives. And in case law, even where someone has been found incapacitated, the court has still found that a durable power of attorney and advance directives can be used in place of a guardianship, even where there is a determination of incapacity. And so, continuing with the legal basis, just wanted to touch briefly on ethical obligations as a lawyer. If you have a client that has diminished capacity, you are not required to seek a determination of incapacity. And if that person needs another person to support them in the legal process, having them there is not does not waive attorney-client privilege or confidentiality. Part A of this rule says that you are to have as normal of a relationship with this person as possible. So here's the bill that was passed, that was filed just recently for the upcoming legislative session in Florida. If passed, it would require the petition for guardianship and guardian advocacy to state why other assistance, such as supported decision making, is inappropriate or insufficient to allow the person to independently exercise the person's rights. And it would define supported decision-making agreements in Chapter 709, which is for power of attorney. This codification is important to give guidance for the direction to impose the least restrictive alternative. It's something that can be pointed to on the books in the statutes that say, here is one option for the less restrictive alternative. So the elements of an agreement, it's a written document, preferably. It's something that you can show the court to say, hey, here's what we have set up and here's what is working. So it is preferred that it is a written document. Designate supporters and alternates. Supporters help make informed decisions in multiple ways, and these again correlate with the different steps of the decision-making process. Then it has signatures, and this is signatures of both the decision maker and the supporters, and then a notary block. This is not required, but recommended since it will be required if the current 2024 legislation passes. And so drafting the agreement, you'll need the decision maker's information and the types of decisions that may require support. This can be financial, healthcare, day-to-day, but it can be tailored to the individual. So not every agreement is going to look the same, but those are some examples of where a supported decision-making agreement may be helpful. And then you will help the decision maker to identify appropriate supporters. So this does not have to be the same person for everything. It can be different people for different things. Someone who is comfortable with having a person help them with their finances might not want the same person to help them in the doctor's office to make healthcare decisions. So they have control to choose how they want the people that they choose to help them in their life. And then the option for the client to end the agreement at any time. Again, this is important for them to retain autonomy and be able to have control over their and the autonomy over their life. And here is a sample supported decision-making agreement. Just helpful. Again, this is an example. Some may look different from this, but it has the decision maker's information at the top, the areas where the person needs help to make a decision, and then how they expect their supporters to help them, how they express themselves, and then the block for the information for the first supporter. Just to give you an example of what that might look like. And then here is an example with pictures. So pictures can be important. Like we said, we want people to be able to understand. Part of supported decision making is giving people information in ways that they can understand. And having pictures in the agreement doesn't make it any less valid. There are very different reasons why someone may benefit from the use of pictures. Someone may be dyslexic, English might not be their first language, maybe they're just visual learners. And so having pictures can help ensure that the person understands what they're signing, which is very important. We don't want this to be something that they just sign because it's put in front of them. And it's not a sign of incapacity. It's another tool to allow them to understand what's being put in front of them. And I think even like the legal document is important, but the process of making this agreement and collecting the information can also be a transformative process. And so to talk about that, I'd like to invite Morgan who is an advocate investigator at Disability Rights Florida, to introduce herself a little bit further and talk about that point.
My name is Morgan Patipa. I'm an advocate investigator with Disability Rights Florida, like Abby said. And I primarily am the one that handles supported decision-making agreements at Disability Rights Florida currently. So I get to do a lot of the groundwork and kind of put my boots on the ground and experience a lot of situations with drafting supported decision-making agreements for different clients with varying levels of ability. So I'd like to kind of highlight one example of a client interaction that I had a couple of weeks ago, and how this process in and of itself, like Abby said, can be so transformative. So I had a client who he was verbal, autistic, but he really didn't have a lot of confidence in himself and his abilities. And we talked about one of the questions on the supported decision making agreement template that we were using was things like, going shopping in a grocery store. Does he need assistance with that? And we talked it over, and he said, oh yeah, of course. Like, my mom is gonna have to help me. My mom is gonna have to drive me there, and she knows what I like to eat, so she's gonna pick it all out. And I invited him to take a few seconds to kind of consider that and consider if that was a decision that he would like to make himself, as opposed to having help from his mom, and being so quick to decide that his mom was the one to make that decision for him. And after a few minutes of us kind of talking about it and talking about what he really thought he could do and what his capabilities were, he decided that, you know what, I, you're right, Morgan. My mom can drive me to and from the grocery store, but she doesn't necessarily have to pick out what I want to eat. So it was just a really interesting moment, because it was like a light bulb turned on, and that he was able to realize that he had the power to make that decision himself, and he was able to make that decision himself regardless of what he how he felt in terms of what his abilities were. And it was just a really interesting example of how these agreements and the drafting of these agreements can be transformative, because these clients, and I see this a lot in my work, that these clients are able to realize how independent they actually can be and what their abilities actually are. And they get a chance to kind of explore what that is through the process of making the supported decision making agreement. So that's a really interesting aspect of this type of work, and it's cool to watch.
Yeah, thanks so much, Morgan. I found that story to be very interesting, and again, highlighting not only that this process can focus on what the person can't do, but also what the person can do. I found to be just as important in this process. So we'll move on to supported decision-making examples. Again, this can be tailored to a specific individual, but these are broadly some of the categories that you'll see. Using in the medical realm an authorization or power of attorney, so that they can have their supporter with them at the doctor to help make medical decisions with them, work with them before they go to the doctor to remember what to ask and to write those questions down. In the financial realm, they can ask someone who is good with money to help them make a budget and review spending. Perhaps that's weekly or monthly, or if they feel comfortable, they can designate a representative payee to receive and manage Social Security or other benefits on their behalf. In the legal realm, they can ask that contracts or other documents be sent to them and their supporters so that they can be reviewed with their supporter and understood before signing. And other things, asking people in their life to call them and visit them and talk about how they're doing or any support that they need, and possibly help set up an app or other system to help remind them of daily to-dos and appointments. Some of these may seem bigger than others. Maybe some of these things don't seem like a huge deal, to some people, but it's really all of these little things, the day-to-day things that make up our broader autonomy and our self-determination. So it's about putting a system in place to make sure that people are supported at this level so that they retain all of their rights to make decisions as they see fit. So when it applies and when it doesn't, the person must have a trusted supporter, and trusted is in bold. They have to trust the person and they have to be trustworthy. The person must have some capacity to advocate for themselves. Again, we don't want people signing an agreement just because it's put in front of them. We want them to understand and really participate in this process to make these decisions. And it's most beneficial where the client may increase or maintain their current capacity. So that is very case specific, might not be the case with some aging older individuals. So some example client scenarios. A disabled student is eligible to remain in school until age 22. Their parent has been told that they need a guardianship to remain involved in their child's education. So this happens all the time, and it's important to pause, ask questions, ask, do you think you need this? Try to figure out what is the end goal. And in this case, the end goal is just to get information in regards to education. So supported decision-making agreements can give a parent that kind of access and would be a less restrictive alternative. If they proceed with guardianship, that comes with a lot of other rights that are taken away, but it's sometimes seen as the only option. So it's important, again, to just remember the end goal. Similarly, with the teen in foster care, will be aging out soon. They have supportive adults in their life, just none who are able to take custody. Again, think about what the end goal is. Is it just to help them through this initial setting where they're in a transition period? Well, do they need this? What other instruments are good for can be used to achieve this end goal? And so supported decision-making agreements can help someone navigate a sort of tricky period in their life when aging out of foster care. And I think for these two specifically, it's also important to point out that if in these two situations, the teen in foster care and the disabled student were placed under guardianship, then this means that they are never at any point able to make their decisions about their life. They go from either the parent or the state as the guardian straight into guardianship, and they don't get that dignity of risk that we talked about in the beginning. So more scenarios, the child of an older adult is concerned about their aging parent. The parent has not had any major issues yet, but their child believes that they may be vulnerable to manipulation due to their age. This is an example where, including them, having someone to support them with their decisions can be really helpful. But being worried someone will be vulnerable isn't a reason to take someone's rights away. So in this case, guardianship may not be or is really not appropriate. And then a disabled adult is encountering health issues and is having difficulty understanding their healthcare needs and options. This is another thing that having difficulty understanding isn't a sign of incapacity. It's a sign that they're going through that decision-making process, and maybe they've hit a roadblock, maybe there's medical jargon that they don't understand, but they're attempting to go through this process. So keep these scenarios in mind as we go into more restrictive decision-making options like guardianship, and evaluate for yourself which would be the least restrictive option in all of these scenarios. So other legal mechanisms, we have guardianship, we have voluntary guardianship, where someone can enter into one. We have emergency guardianship, where an emergency petition is filed, and then they get an emergency guardianship for the span of 60 days, and then the full proceedings have to happen after that. But in certain circumstances, it it can be expedited in that way. There's a limited guardianship where some but not all of the person's rights are taken away. And then plenary or full guardianship is where all of the person's rights that are able to be taken away are taken away. And guardian advocacy is essentially the same thing as guardianship. It's slightly different in that it is available to people with developmental disabilities. And because under guardian advocacy, the person must lack some but not all decision-making capacity, so they must retain at least one right. And under guardian advocacy, there's no finding of incapacity. It's based on this developmental disability designation. And so here is a triangle representing these decision-making options. At the top, we have self-determination, this unrestricted ability to make our decisions. And just beneath that, we have supported decision-making. And this includes the supported decision-making agreements that we've been talking about, but also includes advance directives, living will, power of attorney, healthcare surrogate designations, and other legal instruments. And some people see advance directives like a power of attorney and healthcare surrogate designation as more restrictive than supported decision making, because it gives substitute decision-making authority constrained by the agent's fiduciary liability. But with a power of attorney, you can go to the bank and act without them, whereas with a supported decision-making agreement, you are not able to bring that document and act as if you were them. And then a step down, we have a representative payee, which is someone who receives Social Security benefits or other benefits on the person's behalf and has to manage it in their best interest and to meet their needs. This is slightly more restrictive than the other things that we've been talking about, because this is overseen by the Social Security Administration, and they ultimately choose who would be a fit representative payee. And if the person wants to change it, they have to go back through the Social Security Administration, and they will determine if they have good cause to do so. And the representative payee must use the funds to make sure that the person's needs are met. So the individual doesn't have as much discretion, can't necessarily direct the representative payee how the funds will be distributed. And then on the last rung, we have guardianship, which, as we've been talking about, is the most restrictive and includes all of the forms of guardianship that we've talked about, including guardian advocacy as the most restrictive decision-making option. So we talked about the statutes that have the legislative intent that reference the least restrictive alternatives. I thought that this part of the statute was incredibly interesting. It says, "It is the purpose of this act to promote the public welfare by establishing a system that permits incapacitated persons to participate as fully as possible in all decisions affecting them." And then it has a list of different areas. Through providing, in each case, the form of assistance that least interferes with the legal capacity of a person to act in her or his own behalf. So wherever there is guardianship or not, the person needs to be able to act for themselves wherever they can. And so supported decision making is often referred to as an alternative to guardianship, but guardianship really is meant to be used as a last resort. I think saying that supported decision making is an alternative to guardianship implies that guardianship is the default, and I think that language is really important. So I would just careful how we talk about things, but guardianship grants substitute decision-making authority. So again, the guardian can go and act as the individual, and guardianship is said to evoke a kind of civil death for the individual. There's a category of rights that are just completely taken away, and then there's a category of rights that are transferred from the individual to the guardian. So the rights that are completely taken away are the right to marry, the right to vote, the right to drive, so they can't have the driver's license, the right to work or choose their employment, and the right to travel. So a person under guardianship would have to ask the court if they wanted to leave the county or the state. And then the rights that are transferred to the guardian, the right to contract, sue, make healthcare decisions, your social life and your friends who you hang out with, the gifts that you make to other people, and where you live. Those are all transferred to a guardian. So it really is like, I think about what life would be like if I didn't have these rights, and it would be very isolating, even if I just didn't have the right to drive. That is already changing my life in an extremely profound way. So and the right to contract, that's buying a house, that's hiring a lawyer. Think about how many things that we have to sign for ourselves, in a given year. So not being able to do a lot of these things is very restrictive for the individual, and that's why we say guardianship should be a last resort, because of how restrictive it is. I can't I can't underscore that enough. Think about if you weren't able to choose who you were going to hang out with, if you had to go to a guardian to approve talking or hanging out with your friends. So it is something to think about. And guardianship is also really hard to unravel, even though the statutes provide that guardianship cases must be reviewed at least annually, and the ward must be restored to capacity at the earliest possible time, the ward being the person under guardianship. It's incredibly difficult. There is a process for it. We won't get too into it, but there's a filing suggestion of capacity. The court appoints appoints a physician to do a medical examination. There are objections that can be filed within 20 days. An evidentiary hearing is held if there are objections, or if the court finds that it's necessary, and then the court must be satisfied by preponderance of the evidence that restoration of capacity is warranted. So, and there are a variety of different reasons why guardianship proceedings, people stay in guardianships longer than perhaps necessary, but this kind of case is I think hard for people to get into the weeds of, and so sometimes judges can act as a rubber stamp for these, despite the statutory language being what it is. And so we'll go into guardianship pipelines. That is, there are certain instances where people fall into situations that tend to lead them into guardianships. So hospitals, if they have someone who has a medical emergency and becomes incapacitated, and the person does not have a healthcare surrogate designation signed or a proxy to make medical decisions for them, um, the hospitals will often seek a guardianship to be able to do things like move them to a different level of care or make medical decisions. And this is despite the fact that the incapacity is often only short term because of their medical emergency that happened. And then similarly, long term residential and healthcare facilities seek guardianships for similar reasons, but also sometimes do it to ensure payment or in cases where the resident is considered challenging. And so schools, we talked about this a little bit with the examples. Students with disabilities who opt to stay in school until age 22 are often urged into guardianships before they turn 18 for their parents to stay involved in the educational decisions. And now that we've talked more about what guardianship is, I invite you to think about if that is necessarily appropriate. And youth and foster care are evaluated every 6 months by a judge, and guardianship proceedings can be initiated within 180 days of a child's 17th birthday. So this increased supervision by the court leads them to more often be put under guardianships, and it is often argued as the only way to provide ongoing support for the child. And again, if we think about the end result and the other alternatives to guardianship, that perhaps maybe this is not the most appropriate. So we have to think about the individual circumstances in which people are approaching guardianship or other decision-making alternatives. And then, so these scenarios create a slippery slope. People are stuck in a system without autonomy or self-determination because because guardianship is incredibly hard to get out of. As we've mentioned a couple times, there are alternatives in the educational setting. This can be a FERPA release, so you can get informed consent for the parent to get access to educational information like the grades, but doesn't give any decision-making powers. You can do this through a power of attorney or a supported decision-making agreement. So this is just, one example for the educational setting, but alternatives can be found for, other scenarios that mentioned in the presentation and others that you may come across. And so potential for abuse, people are concerned about the potential for people under supported decision-making agreements to be taken advantage of or abused. But as we said, supported decision-making doesn't give anyone else the power to act on the person's behalf. So that in and of itself lessens the likelihood of abuse. And people with supported decision-making agreements have a network of support and have ties to their community that help protect against abuse. Whereas with guardianships, you have one person who has a lot of control over the individual. If it's a full guardianship, you have access to their finances, and you can control who they hang out with, and so it can in some cases promote isolation and weaken an individual's ties to the community. So there's a potential for abuse. In none of these options are going to give you a complete elimination of that possibility, and bad people are going to do bad things, and so yes, there may be a potential for abuse, but from what I've come across, it is less than in some of these other alternatives that give the person actual power to act on the person's behalf. And we have supported decision-making in dementia. Kind of quickly go over, it's important for people with dementia to have supporters and not just healthcare surrogates to just make decisions for them. It's important that we include them in the decision-making process and give them all of the information. Variation exists in dementia. It's not one size fits all. And even person to even within a specific individual, day to day, someone might be different, or maybe have better capacity in the morning than late at night. So supported decision making allows the person with dementia to convey preferences, values, experiences with no overriding assumptions of ability to do so, which is important for someone who may not have the same capacity, throughout the day or day to day. So protections against guardianship, we can execute advanced directives that may suffice in place of guardianship. So as we saw earlier, the courts said that a durable power of attorney was sufficient in place of a guardianship. So those can be drafted. Supported decision-making agreement, healthcare surrogate designation, filing a pre-need designation or pre-need guardianship form with the court, which is a form that gets filed that names the person who the individual would like to become guardian if they're ever deemed incapacitated. This can also be included in a supported decision-making agreement. A limited guardianship, so if guardianship is ends up ultimately being necessary, you want to advocate for the rights that are removed to be as limited as possible so the person can retain all of the rights that they have capacity in, and guardianship as a last resort, as we've been talking about. But I think it's also important to point out that even where guardianship is deemed necessary, and maybe even a full guardianship, guardians can and should incorporate supported decision-making principles and this person-centered approach to include the person in the decisions to the highest extent possible. And this can also go towards their obligation to restore capacity at the earliest possible time. So even though they may get transferred the right to make certain decisions on behalf of the ward, the person under guardianship, they can work with the person to go through those steps, even though they have the legal right to make those decisions on the person's behalf. And testimonials, these are just quotes from people who have been using supported decision making, and I really like this one on the bottom right, the orange, that says, "I have good brain days and bad brain days," because I think we can all sort of understand, even if not in that language, when we're overwhelmed, or we've had a long, hard day or week. It can definitely be incredibly hard to make decisions. The last thing that we want to do is make another decision. So I like these testimonials from people who have used it and have found it to be something that works for them and helps them advance in their life. And on a final note, this is a success story. This is about Michael. Michael was the first person for the court in Florida to order supported decision making in terminating a guardianship. So he was in foster care, and when he aged out, he was in a group home, and he found out that he was being petitioned to be put under guardianship, and ultimately the court found him to be incapacitated and appointed a guardian, and that guardian had controlled various aspects of his life. Before the guardianship, he was very involved in his community and had a lot of things going on, but once the guardianship was instituted, he was no longer able to do those things, and the guardian, had his friends and the people that he wanted to visit had to be on a safe list. So it was very restrictive for him, and he realized that he did not like this, and he did not think that he needed this. And so ultimately, he found a way to get a cell phone, despite his guardian not allowing him to. Like, he told the guardian that he wanted to get a video game from Walmart and use that money to get a cell phone and a prepaid phone card, and called Disability Rights Florida, and he heard about his options and was able to, once he heard about supported decision making, decided that that was something that he was definitely interested in, and followed through that process. And ultimately his guardianship was terminated, and now he has supported decision making in place. And so this is someone who maybe should have never been under guardianship in the first place, and was able to use supported decision making successfully, and he has now become an advocate for supported decision making. I found his story to be incredibly interesting, and I love listening to him talk. So if you want to hear more about that, you can check out the Disability Rights Florida's podcast, or he has an interview with MTV that is also linked in this slide. And so resources, all of these will be available after the presentation. They'll be uploaded, but we have from Disability Rights Florida a lot of really good materials, the ACLU, the ABA, and then the Working Interdisciplinary Network of Guardianship Stakeholders, the WINGs, will all be available. So that's enough talking for me. That concludes. We have questions. If anyone has any, we can try to answer them. But thank you for your time, and thanks for listening.
Thank you so much, Abby. What an incredible presentation. The things that you all at Disability Rights Florida do to protect, people who are vulnerable is just, I'm just in complete awe and very honored to share this platform with you. Folks, I'm going to buy some airtime, by talking about the CLE code and things like that, but please feel free to drop any questions that you have into the Q&A. I'm happy to answer them, especially while we have, Abby and the other folks present who can really answer the questions that you might have. So in the meantime, this presentation was awarded 1.5 general CLE credits via the Florida Bar. That CLE code is 7278. I did drop it into the chat, 7278. And feel free to, claim your credit for joining us here today. I don't see any questions that have come in. Is there any, discussion that wants to be had, amongst us here as speakers? Buy some airtime until about 1 o'clock. We have the floor until then. And so we are getting a lot of folks saying thank you in the chat. And then someone did come forward with a question, and I will read that out loud. The question is, will courts waive annual plans for guardian advocates? Any takers?
Hi there, this is Caitlin Clement. I'm an attorney at Disability Rights Florida. As far as waiving annual plans for guardian advocates, I'm not, that's not something that I'm familiar with. I think that is something that you would need to take to your court on your individual case if you had justification for why the annual plan needed to be waived, and make that request. But that's not something that we typically advocate for at Disability Rights Florida.
And another question that came in, what is the best way to advocate, for 2024 supportive decision-making legislation?
So a bill has been filed. Representative Tant filed the bill in the House. I don't believe that the Senate companion has yet been filed. If you want to advocate, I would, if you want to contact your senator for your local area and tell them about the House bill and suggest that they might want to sponsor the Senate version, that would be one way to advocate. Another way would be to get in contact with your, senator and rep for your area, and again, ask them to vote for the bill if it comes before them in committee or in the chamber on the chamber floor. Um, and and then once the bills are moving through session and they're signed and going through committees, you can also contact the members of each of those committees. And that's all information that you can pull from the websites of the Florida House and Florida Senate. As far as if you look up the bill number, it's HB 73 this year. So if you look up the bill number on those websites, it will tell you which committees it's assigned to and who are members of those committees and what regions of the state they come from.
Awesome. Thank you so much, Caitlin. And I know folks are saying thank you. Great suggestions.
Well, and I appreciate someone, anybody who wants to help advocate for this bill, the more the merrier, and the more folks hear about SDM, the more comfortable people become with it and understand how it works. And I think it would be a really wonderful thing to have it codified to make sure that everyone in all the parts of the states know about supported decision making and are able to use it.
Absolutely. And that a question just came in sort of on that topic about spreading the word. Somebody asked, are they able to share the video of this recording with others? I know we plan on sending a copy of the recording out to all of you who are here and everyone who registered. I also do plan on putting it on our training YouTube, which is publicly accessible. And so I think I can safely say, absolutely, you can share that with whoever needs and wants it and should see it.
Yeah, any of the materials on Disability Rights Florida's website, obviously share those around to advocate for the bill, but also just to individuals who might benefit. And if anyone is ever looking for more information or a direct contact to discuss this, feel free to call us at Disability Rights Florida. You can talk to Morgan, you could talk to me. We'll be happy to help.
Absolutely. And I will also, with the recording, be including a PDF form of the PowerPoint here today. So you should have all those resources in a clickable link and all of the phone numbers and all of the emails. And so, with that, a lot of thank yous are coming into the chat, and, a lot of just appreciation for the webinar overall and the information. And, Abby, I know you did a lot of lifting to get this to us. You did a fantastic job. You're a fantastic communicator and teacher, and it was really, really great to learn from you. I say that on a personal level and professional. It was really, really lovely to listen to you. You're welcome. And also thank you to our ASL interpreters, absolutely, and our cart writer. Without you, obviously we'd have a lot of barriers to accessibility, and you are incredibly important in this process and all of the processes of us communicating about all these important things. So with no further questions in the chat and nothing, I checked the Q&A, I'll double check one more time. I don't see anything in the Q&A. I think on that note, we will end our presentation today. I think, leaving on the positive note of the story of Michael and his success and, all of the wonderful resources. I can't think of a better way not to end this conversation, but to continue on with this conversation and hopefully begin this conversation with a lot of people who may not have been considering it in the first place. So with that being said, thank you so much, Abby, Morgan, Caitlin, Tony, our interpreters. Thank you all in the audience for all that you do, for learning and listening, and for being a part of our efforts to empower people through their choice with its supported decision making. And with that being said, I will end the webinar, and I hope that you all have a fantastic rest of your day and week.